Good afternoon. I'm Ruby Canizares, your treasurer. I'm here to host for today's regulatory hour webinar. As always, FSBBT is privileged to have Dale Atkinson on an ongoing basis. For our potential new webinar participants, I would like to highlight Dale's background. Dale received his law degree from Northwestern School of Law, Portland, Oregon, and is the sole managing member of the Northbrook, Illinois firm of Atkinson and Atkinson that represents various associations of regulatory boards. In addition, Dale represents associations in all matters relating to their operations as not-for-profit corporations. This includes regulatory activities, education and accreditation, disciplinary actions, and other functions. Dale is a frequent speaker for his association clients as well as other regulatory groups, and also produces numerous subject matter writings for publications. I'm pleased to have Dale present today's regulatory hour topic, March Madness Motions, a specific case discussion of interstate reciprocal discipline. Before I hand it over to Dale, I would like to remind you that the next webinar, Clearing the Path, is on Wednesday, March 30th at 1 to 2 p.m. Pacific Daylight Time. Yes, please make sure you remember you have to spring forward for that time. And Jennifer Wissinger and Christina Lunsberry will be discussing ways to identify and eliminate barriers to reporting, investigating, and defining sexual misconduct and boundary violations in physical therapy. And as always, Dale likes to be very dynamic with his question and answers. So please plug in your chat questions. I will be muting very shortly and turning off the video, but I will monitor, and Dale will also monitor chat questions, and he will answer it as we go along. And without further ado, I'm going to hand it over to Dale. Welcome, Dale. Thank you.
Thank you, Ruggie. You know, there are speakers that need no introductions, and then there are introductions that need no speakers. And so I don't know if I fall into either one of those. I hope probably not either of those, but just to get us started, hopefully that makes you guys smile a little bit. So I'll add my welcome as well, and to the regulatory hour for this month, where we are going to discuss probably one of the shortest judicial opinions I've read that has the most issues that I've also ever read within a really short, compacted opinion itself. Judges can be quite verbose, as lawyers can be, and I'm probably one of those. And as I do like to say, that I get paid by the word, so sometimes I go kind of fast, but we'll slow it down to make sure that we take the time to address issues and address questions that you may have and that may surface. And so let me get this slide to advance. All right, so as I always start out with, and while I want to be funny every now and then, I do want to give a big sincere thank you. You guys rock. And so, first off, to the FSBPT Board of Directors for dedicating the time to have these webinars, and not just the regulatory hours, but you have multiple webinars where you as regulators have opportunities to interact with one another and hear some content, and where we can all learn from each other. And I hope that you all, send your thanks also to the Board of Directors, the FSBPT staff for all the work they do to put these together. So a big shout out, thank you to you both. And then the biggest thank you goes to you all who are on the line as participants. I'm going to call you not attendees, you're participants, but I know that you are regulators. Many of you are volunteers. Some of you, of course, might be executive directors, administrators, assistant attorneys general, investigators, inspectors, what have you. You all play such an important role in enforcement of the Practice Acts in the interest of public protection. You're not thanked enough in today's day and age and in the climate that we're in of late. Again, I don't think there's enough recognition for the regulatory community. So I will take the time to recognize you and give a big thank you as we launch our way into the additional content that we're going to talk about. So as mentioned, I do want you to participate, and you can do so by chatting. You can unmute and shout something out. You can raise your hand. We'll try to keep our eye on as much as we possibly can. But I do want you to chime in, ask some questions. And I think as we meander our way through this particular case, there are going to be plenty of opportunities for you all to chime in with one of two things. One is, gee, what is the issue here? I'm not sure I'm understanding. Or two is, in our jurisdictions, here's how we might treat this particular situation. Now, this is a medical board case, but the issues transcend all the regulated professions. And so feel free to digest the materials and truly participate, unmute, speak up, type in a chat, whatever it takes. And so we'll start out just to warm you guys up to see if you're listening and awake. So pick one of these two. No need to explain your pick, but let's just see if a few chats come in. We've got a 2 coming in and a 1 coming in, and now back and forth. So excellent. So you guys are listening. That's cool. And it's nice to dream about these pictures, especially as we move our way into springtime in whatever jurisdiction you might be. And as those of you who are veteran attendees, I always have to bring up hockey. And so here's a picture right here of the CenturyLink Arena. This is in Boise, Idaho. My son left high school to go play junior hockey. This was their home rink. And I did not take this picture. However, this picture was taken from a conference room in which is part of a hotel, which is attached to the arena. So the only reason I bring this up are a couple of reasons. One is we have to have our hockey reference, right? And we all have to root for the Blackhawks right here behind me. And then secondly is as FSBPT considers where you may be having future meetings, Boise, Idaho is a lovely town. You could stay in this hotel and you could have meetings overlooking the rink. Well, I'll tell you, if you have one of those, please invite me to that meeting. And so hockey reference, always fair game to talk about hockey if anybody has anything to say. So now did you see the logo? I did put the logo there. There you go. It's, I tried to dump that logo so it looked like it was in the ice. So well done. Well done for somebody seeing that. All right. So now to continue our chat and participation, pick one of the following issues and just type in a number in the chat. I think these will all surface, but maybe you would pick an issue that you don't understand. And so you're going to want to know more about it. You may pick an issue that you say, I know a whole lot about. Either way. So again, this is just to make sure you are listening. So we see a few that are coming in. What's a voluntary surrender? Number 1. What is summary judgment? Number 2, or summary decision, it might be called. Does the physical therapy board renew disciplined licenses? That's an interesting question. And then lastly, does lack of good moral character form the basis for an adverse action? We're used to talking about good moral character in a setting of should we issue a license or perhaps renew, but does it form the basis for an adverse action? So I think we'll touch upon probably all of these issues. If I gloss over something that somebody wants to know more about, please chat or unmute and let's keep the discussions going. Very quickly, a little bit about me. As mentioned, the bio is read. I'm an attorney in private practice and represent a whole bunch of FSBPT-like groups. I know most of you on the line are probably veterans, but it's really good for you to know what your organization is. And that is a not-for-profit organization whose members are comprised of government boards. And FSBPT is a private organization, not-for-profit, and it has perhaps more latitude with certain issues than government does. And there's benefits to that. And but as mentioned, I represent a bunch of groups like yours. And most of my clients develop, administer, score, and maintain a uniform licensure exam program, but a lot of other aspects come up, including webinars like this. And so take advantage of knowing your organization, take advantage of getting to know one another and exchanging content and information that will help you become, if you will, the best regulators that you can possibly be. And so this is my world. It's been my entire career, and I hope some of my experiences have will shine through and be beneficial to today's discussions. We talked about January judgments. You can see the alliteration theme we have going throughout 2022. So today is March motions, and we'll probably focus on that motion for summary judgment a little bit, or motion for summary decision. And then we have other topics coming out throughout the rest of the year. So stay tuned on the details of those, but we'll focus on that on March motions. And there'll be a little splash of trends that are going on related to the regulatory community. And so again, feel free to jump in there. Stolen from Wikipedia, which I go to for all my legal source here, is what is a motion for summary judgment. The very, very short version is it's a decision made by the court without having to have a trial on the merits or without having to have any fact finding, because all the facts are established and agreed to theoretically by the parties, so that there is an issue only as a matter of law on the table. So you don't need to have a trial. It's a motion, and it's a procedure that allows a case to perhaps move more quickly. And it also is probably a cost-saving measures to at least to the movement who wants to have summary judgment entered in their favor. And so can this mechanism come up in your worlds? Think about that. Can it come up in an administrative setting? Think about that. And it comes up consistently in a judicial setting as well. And so we'll try to tie some of those loose ends together, but we'll start out by laying a little foundation. We're not trying to turn you all into lawyers. That's all we need are more lawyers. I think I've said this before with this group, but right now in Chicago alone, there are over 90,000 lawyers licensed. And so it is a big profession. And my anti-competitive statement of the day is perhaps we don't need more lawyers. But on a serious note, you all ought to have some basic understanding of some of the issues that might surface before your board, and whether we're talking about due process and a fairness issue, right on down to a technical issue like some kind of a motion for summary judgment or summary decision. So it's worth paying attention to that as well. And I've chosen in March here in our March Madness and our March motions to follow kind of a bracket approach. It was really hard. I'm not real great with PowerPoint slides. I feel like I tried to make some brackets, but we'll start with this big bracket here, and we will eventually work our way to brackets on the slides that you'll see upcoming. But the case we're going to talk about is Knight versus the Board of Registration in Medicine. It's out of Massachusetts. It's a Supreme Court case out of Massachusetts, and it was decided in May of 2021. And as I've mentioned, it's a relatively short opinion, but it's just chocked full of issues. And I want to take my time in navigating our way through the facts. And so as I address the facts and pose issues out there, feel free to interrupt at that point in time to talk about how it may relate to your jurisdiction and some of the issues you either may have seen and want to tell us about, or where it creates a question where you don't know perhaps what you can and cannot do under a particular circumstance. And so let's start winding our way through. And I'm going to stop, as I've mentioned, at various points. I've underlined some other points that I want to emphasize, but feel free to chime in there and use the chat or unmute. So we're dealing with a physician who is licensed in Oklahoma, and you're going to find licensed in multiple jurisdictions. But let's start here in April of 2009. And this, by the way, gives you an idea of how a fact pattern can stretch itself out over a very long period of time. And eventually we're going to ask ourselves, what is too long of a period of time? And is the public at risk? And I'm not suggesting that it was or wasn't in this case, but you can understand when I start a fact pattern in 2009 about a case that was ultimately decided in 2021, a lot of time passed, obviously, between those. So April 2009, licensed physician in Oklahoma, practicing in Oklahoma, was the subject of a complaint. And so we can stop right there and say, what is a complaint and how does your board handle it? That's probably basic information for each and every one of you, but you ought to know that. And the first question I might ask is, what if the complaint is anonymous? And in this case, it wasn't, but what if it is? How do you handle that? Anonymous complaints versus complaints that must be signed. And are anonymous complaints just tossed aside, or do you actually consider investigating them? I think it's bad policy to say that anonymous complaints won't even be investigated, obviously depending upon the severity of what is being alleged. But question number one. Next up, you can see here the complaint came from a pharmacist. And this is a pharmacist who is concerned over the prescribing practices of the physician. So this is a really great example of related, if you will, professions or professions that overlap each other or professions that can see what each other are doing. Pharmacists are a really good example of this. And when they should step up and file that complaint and what it may look like. So obviously this pharmacist understands and looks at the scripts and sees that it's the same physician prescribing perhaps excessive amounts of either addictive medications or pain management practice, whatever it might be. And so one professional filing a complaint against another. We can also step back and say, do physical therapists file complaints against other physical therapists or any profession that you want to choose, and how that might surface, and whether there is either added credibility based upon where the complaint came from versus perhaps less credibility. And obviously, I haven't even mentioned yet a consumer filing a complaint for whatever it might be, whether it's a competence malpractice issue or a boundary violation or anything else that surfaces. So we have a professional here filing a complaint against another professional, different professions. By September of 2009, an additional complaint was filed also by a pharmacist. And by the way, one of these two pharmacists, I don't remember which one, actually had an encounter with the physician who came in to fill a script for a family member and appeared to be impaired. And so the pharmacist who filed the complaint actually referenced the potential impairment of this physician based upon that encounter, in an in-person setting at the pharmacy itself. So you can see here the importance of ensuring that people understand when and if they can file a complaint. I'm going to throw in just a quick comment here about the consumers. Do they know they can file a complaint? And do they know where to file that complaint and everything else? And this is a topic for another day, but regulatory boards ought to pay attention to their outreach to consumers and others to ensure that a consumer, a knowledgeable consumer, or I should say any consumer, understands they can file a complaint with the regulatory board, and potential action can be taken if wrongdoing is substantiated. So that kind of knowledge is very important here. Obviously, professionals know they can file complaints against other professionals. So in September of 2009, the Oklahoma board issued a letter of concern. Now, some of my remarks may be interpreted as being critical, and so be it, perhaps. But I would ask first off, what is a letter of concern? This is a serious issue on the table, prescribing practices, and is a letter of concern enough? I'll let the board decide that, but I would ask some more questions. What is a letter of concern? Is it public? Is it available? Is it a so-called mark against the licensee, or is it private, not subject to disclosure? And how does this all boil down? And I ask that because this is such an important fact pattern, what's at stake here. And what I'm going to tell you on the next slide, and I'm going to tell you now, though, is between 2009 and 2011, 9 patients of this physician died of drug toxicity issues. And so this letter of concern here strikes me as a perhaps not severe enough approach, and maybe there are reasons for it, so fine, but let's just at least bring that up as an issue for you all to understand. Now, during this time as well, the physician was under investigation by the DEA. You all know that your relationship, physician's relationship provides them with prescribing practices and others. So the DEA was in here and involved in some investigation ongoing. In August of 2011 now, so this is 2 years later, the physician accepted a new role in Boston at a health center, and as you can see here on this next slide, relocated to Massachusetts. So we have now an issue of a physician looking to get licensed in an additional jurisdiction. Okay, and we have a letter of concern by a board, and we have a ongoing DEA investigation. And does this ever surface, and under what conditions? And I know Rich and his staff at the FSBPT, talk about your programs and the ability to provide information to the membership through the ELDD and other relationship issues you can forge as an organization. Remember, you are FSBPT, so you have hopefully the right to gain information. So when is it disclosed? So So back to our case now and the facts. The physician applied for licensure in Massachusetts. And so we're going to ask ourselves, well, gee, what does the application say? The next big issue is, how do you phrase your applications for licensure? What questions do you ask? And how might they be phrased in a manner where I, as an applicant, have to be truthful, if you will, forthcoming about what is going on in my regulatory or professional life? And so, do you ask about ongoing investigations? Do you ask about final adverse actions? Do you ask about anything related to competence or complaints, malpractice actions, civil lawsuits, criminal investigations, however you phrase those? And again, that's a seminar in and of itself. So be thinking about that. But the Massachusetts application asked about pending or prior actions by a government authority. Specifically, it said if the applicant, the physician, has any knowledge, had any knowledge of pending investigations into his professional competence or conduct by any government agency. Interesting phrasing, not being critical of it, but will that elicit appropriate responses so that the board, Massachusetts in this case, can make an informed decision about licensure eligibility? Each and every one of you on the line today ought to review your applications for licensure and renewal on a periodic basis and clean them up if they need cleaning up, or at least you're satisfied with how things are phrased. As you can imagine, the physician answered no to that question. And in part, probably it's plausible that his no answer is accurate, because what is a letter of concern? And is that something that is pending? No, it's probably over, it's finalized, but is it an adverse or disciplinary action? I don't know. We're going to get to that in our bracketology slides. So be thinking about that type of issue. He actually answered no twice because he had to amend his application on a different unrelated issue, and he answered no again to that question about pending investigations into competence or conduct. So in March of 2012, and according to the judicial opinion here, in relying upon that no answer, the Massachusetts board issued a license to this physician. So now he is duly licensed in Massachusetts. He is working at a health center outside of Boston. And in October of 2012, how many months later is that? Not very many. He was removed from the facility and he was hospitalized for a short period of time based upon some mental health issues. So his erratic activity, led to this hospitalization. Now, again, we can throw into the mix here confidentiality issues and HIPAA and any other, related to what boards should know and when they should know it. But we now know that this did occur. So he resigned from his position with this health center. And again, there's another issue, I didn't even underline it, and that is resignation from a position versus he was terminated. And in some professions, and pharmacy being one of them, if you are terminated from a position, that may be a reportable issue to your regulatory board. And I'm not sure if that's true in physical therapy. Somebody feel free to weigh in if it is true, so we hear it from you and we know. But is an employment decision relevant to or a reportable event of a licensee and an ultimate administrative action? So now this resigned physician relocates to Arizona. Nothing in the opinion references any application for licensure in Arizona. So I don't know if that became relevant. We did look up some physicians in Arizona just for fun, and we found a couple, and I'm not sure if it's the same person or not, but be that as it may, now this person is no longer in Massachusetts, and you're going to see here some things start happening. So let's go back to Oklahoma in December of 2012. So this is now 2 or 3 years after the letter of concern. The Oklahoma board commenced disciplinary proceedings. So I'm not sure what stimulated the commencement of these disciplinary proceedings. I couldn't figure it out by the opinion, but be that as it may, there was grounds to do that, obviously, in Oklahoma. And as I had mentioned before, 9 patients had passed away of acute drug toxicity between those years. And perhaps that is the stimulus when 2 and 2 was put together and resulted in this Oklahoma board commencing proceedings. So Oklahoma now proceeds. Well, the DEA now around this time immediately suspended his registration. Again, I'm not sure what stimulated that, but it happened around that December 2012 time. And unfortunately, it's just 3 years after the fact. And in April of 2013, so 4 months later, the physician voluntarily surrendered his federal controlled substances privileges. So I underline that voluntary surrender issue because we are going to come back and focus on that in a minute. But what does that mean? What's a voluntary surrender? And I would contend to everyone on the line today that in my mind, there's no such thing as a voluntary surrender. There is an agreed upon consent order or settlement agreement, whatever you want to call it, but I would not refer to anything as a voluntary surrender. I do not want to get into a debate about whether it's a reportable event, whether it's part of a public record, and whether there's a substantiation of wrongdoing, and what about seeking reinstatement or renewal or seeking a new license. There are so many unanswered questions when we start going down that voluntary road. So now let's get to the next issue. In September of 2013, this physician allowed his Oklahoma license to expire. He did not renew it. And I'll remind people, and I think I talked about the Elmer case in a previous regulatory hour with you all, but the very, very short version of the Elmer case, which is an Indiana appellate court decision decided, I believe, in 2021 as well, so pretty recent, where the appellate court in Indiana found that the Board of Pharmacy in Indiana does not have authority or jurisdiction over an expired license. So they could not discipline an expired license. And the court in the Elmer case, the basis for its decision was, well, if Elmer ever comes back to seek licensure, that is when the board can address the issue. And I think that falls far short of recognizing why we have regulation and why the public may be at risk here with the inability of the Indiana board to enter a sanction against this person merely because they allowed their license to expire. All the wrongdoing in the Elmer case, and certainly all the wrongdoing in this case too, occurred while this person was licensed. So be thinking about that issue and how it might apply in your jurisdiction. So now in March of 2014, the Oklahoma board entered an, and I'm going to quote, order of voluntary submission to jurisdiction. So we all have to step back and say, what is that? So we have a letter of concern issued by the Oklahoma board in 2009. And now we have an order 5 years later of voluntary submission to jurisdiction. No findings of wrongdoing, no findings of fact, no sanctions entered or anything else. And as you can see from the next bullet point, the physician agreed that if he ever applied for licensure in Oklahoma, that those charges would be considered. Just like we talked about in the Elmer case, is that good practice? Is that public protection driven? I don't think so, but maybe that's a debatable point. So somebody type something in the chat to make sure I know you guys are still listening. So it can be even the Blackhawks are going to win the Stanley Cup. So okay, so we now have a go Caps. We now have a this order of voluntary submission to jurisdiction. And I don't know what that is. But I will tell you this in a footnote in the judicial opinion, this order was originally an order of a voluntary surrender of license. And I believe the lawyer for the physician probably made some kind of an argument that they did not want this voluntary surrender on a record, I'm guessing here. So they somehow talked their way into this order of voluntary submission to jurisdiction. So everybody with me on the facts and some of the issues? So somebody give me a thumbs up in that. So now, in March of 2014, right after it issued this order of voluntary submission, the Oklahoma board reported this to the National Practitioner Data Bank. So they deem this, the Oklahoma board, deemed this to be an adverse action that was reportable to the NPDB. And I think everybody on the line is familiar with that. So with the data bank. So now it becomes known, if you will, through the federal data banks. And obviously the Massachusetts board found out about it. So there's another question is through the Federation of State Medical Boards, which is the FSBPT of human medicine, is there a data bank available and others? And so how do boards benefit from their collective wisdom and from their relationship via a group like yours, FSBPT? And it's important, I think, to understand some of the benefits that exist by sharing of information, because it's otherwise public. And no organization like yours would ask for information necessarily that's not otherwise public. So it's available to be found. So stimulated apparently by the National Practitioner Data Bank reporting, the Massachusetts board moved for a summary suspension of the Massachusetts license. So now we can see this whole web untangling, if you will. But in April of 2014, so immediately after this move for summary suspension, the Massachusetts board ratified the voluntary agreement of this physician to not practice in Massachusetts. So here we go again. Now we have nothing on the merits yet that would substantiate in a public setting, if you will, what has potentially gone wrong or has gone wrong. And so now we've got an inability to practice in both Oklahoma, subject to the voluntary submission. We've got a voluntary agreement to not practice in Massachusetts, subject to that agreement. Are both of those public? I think they are, but I'd ask, we can ask ourselves that question. And I do realize, and I'm going to say this too, is when I search board websites, I do a lot of this. And as I mentioned, I work with a lot of federations like yours in multiple professions. It's sometimes very hard to find information on your websites about the good standing status of a licensee. And so, this might be another good example. Somebody, if you want, go ahead and search for Knight. His first name is Joseph Knight. So anyway, so now we have this agreement, voluntary agreement to not practice. In July of 2014, in the midst of all this, the physician submitted his renewal application for licensure in Massachusetts. And he is in Arizona, by the way, right now, during this time period. And so next question on the table is, you've got a voluntary agreement not to practice, and then you have a renewal application submitted. Does that make a difference? Maybe, maybe not. Ask yourself that question. And as we keep going with this unwinding of our fact pattern, but think about how you would react to that. On the renewal application in Massachusetts in 2014, and by the way, I'm going to jump back very quickly, and when he was issued his license in Massachusetts, which happened in March of 2012, sorry about this, I'm probably going to mix everybody up, but in March of 2012, in August of 2012, he had to renew that license. I'm not sure why, but he again answered no to the question about is there's anything pending in other jurisdictions. So it gives you a flavor for this physician, one, but it two is also gives you a flavor for how questions might be phrased and whether that letter of concern was actually an action that was reportable on an application for renewal or an application for initial licensure or endorsement or reciprocity, whatever you call it. So on his renewal application, so I got this what? Okay, and I see people are listening, so thank you for text or for chatting that in. So on his renewal application, the physician disclosed the actions in the other states, but he said there was no discipline in Oklahoma. So this is back to that question I've asked too many times already, and that is, what happened in Oklahoma, and was that a reportable offense? It certainly was in the sense of the National Practitioner Data Bank in the eyes of the Oklahoma board. So now we're starting to get much more clear about, is this physician really going to be forthright with his answers to questions? So in March of 2016, so here we are 7 years after the fact, 9 people have died that were under his care, if you will. March of 2016, the Massachusetts Board issues the following allegations: fraud in the procurement of a license. So he was not truthful, perhaps, on the application. Reciprocal discipline based on the Oklahoma action. Okay, so you think about that. Practice while impaired. The failure to report the Oklahoma action. Okay, so the mandate to report, whether that exists in your jurisdiction within physical therapy, think about that. And then let's just toss in there a summary suspension of his Illinois license. I couldn't figure out where that came through, but it was just thrown into this judicial opinion. So he was obviously licensed in Illinois and was subject to a summary suspension. It was not expounded upon by the court, but it was tossed in there. And so we have a physician license in obviously multiple jurisdictions. And is there a communication web that is occurring that allows Illinois, Massachusetts, Oklahoma, Arizona to communicate? And how important the federation is for these types of scenarios. The board submitted the matter to the division, which prosecutes the administrative actions, and the board filed a motion for summary judgment. We talked already about that, related to a summary decision. I think I put judgment here. It's technically a summary decision, basically saying that there are no facts in dispute. So let's just get right to it and make the decision, have the decision made. So wrapping up our facts now on the outcome. The division revoked the physician's, and now let's pay attention to the language. They revoked the physician's right to renew his license. So that's a very interesting phrase to use. And does that implicate any different rights or due process protections? Because they called it a revocation of his right to renew versus a revocation of the property interest in the license itself. And so we can debate that and ask ourselves these questions as to how this might apply. This was said multiple times in the opinion, but it was never really explained as to why it was phrased that way. So do you all do that? And do you all sanction someone's right to renew versus sanctioning the credential, the license itself? So you can ask yourself that. So the physician appealed, and he argued there was no discipline in Oklahoma. He is still going to bat on that one, saying that what occurred in Oklahoma is not a disciplinary action upon which reciprocal discipline can be based. You can see it in the next bullet. And that is the use of reciprocal discipline was improper. It's unfair, and there are no supporting facts in Oklahoma, which there weren't, right? There was no findings of anything. There were these agreed upon issues, and how those are drafted is extremely important. So get advice from your lawyers when you get to that stage. And then finally, he did argue a lack of notice of the allegations based on some due process issues and others. Following the process in Massachusetts, a single justice affirmed the decision. It is appealable to the Supreme Court, which also affirmed the decision of revoking the right to renew his license. And the Supreme Court said there's ample evidence supporting the decision, number one. And two is reciprocal discipline isn't even necessary because there were grounds, independent grounds that existed that formed the basis for the revocation of his right to renew. And there was no prejudice to the physician on his arguments about lack of notice. And so it was easy for the Supreme Court to arrive at this conclusion, and it didn't take them very many words, although look at all the issues in this case, in this very short case. So in some of the time here, I want to go, well, first off, if anybody has any questions, feel free to unmute and ask those now, but I'm going to go back a little repetitive and hit some of the issues that I think are important. And here's the first one is licensure in multiple jurisdictions. Okay, do you deal with endorsement statutes? A lot of people call them reciprocity. It's technically probably not reciprocity. And you should know the difference between these two. Endorsement is if I'm licensed under similar circumstances in jurisdiction one, in similar circumstances to jurisdiction two, jurisdiction might issue me a license. Reciprocity is an agreement among or between jurisdictions that says you take ours, we'll take yours. And I don't believe there are many of those left, if any of them. And then I'm going to throw in there your compact and how compacts might have come into play here. Rich, correct me if I'm wrong, but most compacts will say that if you actually relocate and have a new home state, you need to get a license in that home state, and you cannot operate under a compact and move around into these privileged states. So here, this position is moving. We have Illinois, not sure where that even came in. We have Oklahoma, and we have Massachusetts, and now Arizona, where there's physical intent to be a resident. So know the difference between these terminology issues, and certainly and use them appropriately. Judges misstate reciprocity all the time. Oklahoma and Illinois, I put this in here because I'm hoping that Illinois and Oklahoma play in the March Madness, then the slide would be way more relevant. And as you can see, I didn't answer many of these. It was kind of hard to create these slides, and I didn't want to put a lot of verbiage into these answers, so I thought I would explain them. But I'm not sure where the Illinois summary suspension came in, and it's just interesting that licensure in additional jurisdictions, Illinois in this case, was not more discussed in the opinion, but I throw it in there, and I throw it in there just because it looks like an actual bracket in March Madness. So hopefully you all are smiling about that a little bit. Investigations. So the DEA was investigating. So we have a federal side of this. Oklahoma probably was investigated, I'm assuming, but that letter of concern, did that stop any investigations? I don't know, but the question that you all ought to know the answer to is, are investigations public or confidential? And we can ask this two ways. We're not necessarily talking about the data collected in the investigation. We're talking about the mere fact that there's an investigation going on. And is that, and you can see on the right side there, I'm not talking about conclusions, data. I'm not talking about attorney-client privilege or anything that might be discovered. I'm just talking about, hey, are there any investigations pending? And what does the public have a right to know? And what is actually reported to the ELDD, which I believe is final adverse actions, but still, this is an interesting question because this physician moved from Oklahoma to Massachusetts. Does Massachusetts get to find out, well, there's an ongoing investigation? And they certainly asked the physician in the application, but Oklahoma may, I'm going to say may, be precluded from telling anyone that the investigation is ongoing. That's going to be a state-by-state issue. But you all see it surfacing now, and you all ought to be able to figure out and seek some advice as to what the answer to that question might be. So a disciplinary action or adverse actions or final adverse actions, you can come up with anything that you might use in your jurisdictions versus this voluntary submission to jurisdiction. I don't know what that is, never heard of it before. And it certainly is a cause for concern because there were no findings of fact that I know of, and there was certainly not an admission of wrongdoing. But ask yourself, what's the definition of discipline? Okay, and I know some of your boards on the line today, and you don't have to chime in and admit it, but I know some boards probably issue private orders, which I think are not good policy, but they may happen, and that's okay. You may have some reasons to do it, that's okay too. But private orders, meaning it's not subject to public disclosure. So if I, as a consumer, am sophisticated enough and I call your board and say, hey, is Dale's license in good standing? Yes. Are there any private orders that have been entered against him? How do we answer that question? If I'm smart enough to ask it, well, we can't tell you that. Okay. And is that a good use of regulatory, public protection driven perspectives? You guys can think about that and try to answer that question. So good moral character versus, let's say, bad moral character. I think I neglected to mention, but I'll mention it now. Part of the basis for the Massachusetts action was a finding that this physician lacked good moral character. So the question that I posed on that one of those first slides is, does good moral character or the lack thereof form the basis for an adverse action against a license? And is it considered beyond the application for licensure, which is where we're used to having the discussion? Hey, I have a criminal background. Can I get a license? Enough time has passed. I said I was sorry. All the things that might indicate I should be given a license. That's okay. But here, good moral character formed the basis for an adverse action against the license, but let's go back to emphasize, it formed the basis for the revocation of the right to renew a license. So I still grapple with why that language is used, and maybe that creates an argument here as well. So first off, is good moral character required in your jurisdiction? Do you ask questions in your application? Do you ask questions on your renewal? And I would strongly suggest that the applications you ask on your initial licensure be repeated on the renewal, so you're comparing apples to apples. Okay, don't get into, well, since the last renewal, have you done the following? I would say in the last 5 years, have you been? And I would ask it the same way throughout, so that you have a basis for comparing answers in the event someone perhaps doesn't tell the truth. And it's much easier to have consistent questions. So think about that, get legal advice from your assistant AG on how you might phrase those. So is it required even? And I will say this, the trends around the country on second chance legislation that's being enacted, as well as just good moral character in general, are questioning whether good moral character should even be a criteria, a prerequisite to licensure in the professions. And there's significant amount of legislation trying to address this issue. And they're doing it one of two ways. One is just to eliminate it completely and don't ask any questions. You don't get to know as a regulatory board. And two is to limit the scope of your questions. So anything, for example, anything over 5 years old is not fair game. So you have to phrase your questions within a certain period of time about both misdemeanor and or felony convictions. So think about that. How does that affect your world? And is that going on? So everybody should be aware of that. Last point on this, good moral character versus bad moral character. On an application for a licensure, the burden is on the applicant to show they meet the statutory criteria, which good moral character is probably one. In a disciplinary case, the burden is on the board to show that this person lacks good moral character in order to substantiate an adverse action against the license. So be thinking about a little bit about who has the burden, but ultimately somebody's going to have to decide what is good moral character. Very quickly to wrap up the motion for summary judgment or summary decision, no material facts disputed, only issues of law. You don't have to have a trial. It's probably much more efficient, although it still may take a long time to get a ruling out of this, versus a trial on the merits where issues of fact are actually determined by the fact finder, be it the board, be it a hearing officer, or in a civil case, the jury. Civil or criminal case, it could be a jury. So how do these motions play out in the administrative arenas in your jurisdictions? And do you have the right to seek a motion for summary decision in an administrative matter like this one and like the board did in Massachusetts? A fair amount of discussion of summary suspension. And while these aren't competing interests, I put them in here to give us one more bracketed issue, and that is summary suspension, which there is an allegation of imminent harm to the public. And therefore this person should be removed immediately from practice and will have a so-called trial or an adverse action somewhere down the road. Many boards like yours have the authority to summarily suspend, and versus any other kind of sanction that might be done here. I put revocation in here because, and those of you who have heard me before, I'll be a broken record for just a minute here and say, why would we ever revoke a license? If you revoke a license, does that divest the board of jurisdiction over the person? Meaning, in the Elmer case, hey, there's no longer anything you can do to me. Remember that? So I let my license expire. Is that any different than revoking a license? And does that now render your board unable to take an administrative action? So now you're up to the civil and criminal systems, and you all don't want to have to rely upon that. Your job is to protect the public through the enforcement of the Practice Act. So think about what revocation means in your jurisdiction, and does it mean forever? And I guarantee you the consuming public believes that means forever, and it probably doesn't in most all of your jurisdictions. But if you think you can revoke forever, it's going to say permanent revocation, and you'll let that be litigated if you have to. But your statutes will probably address that, and chime in and discuss this with your assistant AG when you have that egregious fact pattern that might merit a removal permanently from the ability to practice within your jurisdiction. Fraud in your procurement of a license versus renewal. I've already talked about mirroring questions on your initial application versus renewal along the lines of good moral character. And in this case, the court found that fraud was used to induce the board to issue a license, and that fraud being not disclosing the Oklahoma action. But it's a debatable point, because that letter of concern and that order of continued jurisdiction are interesting, unique animals in my mind. And so it's a plausible argument to make. And I don't believe that was frivolous at all. So again, versus renewal issues. And then as a reminder, the court revoking the right to renew a license. And that's some interesting language and how that might come up. As I've mentioned, and I'll emphasize, there's no such thing as a voluntary surrender in Dale's naive world. And that voluntary surrender, I think that word voluntary is what we need to remove from the nomenclature. It can be a surrender under a consent order, it can be a surrender of a settlement agreement. Think of a way to phrase it so that it does not look like there is action on the part of the licensee that's controlling tomorrow based upon what happens today. This should be controlled by the boards. And the point of, okay, you're going to turn in your license or you're going to sign this consent agreement. And this consent agreement is going to have all sorts of terms and conditions in it, whatever you guys think is important. But it certainly, in my mind, should include an admission of wrongdoing. And it should be reportable, made public, and subject to disclosure to any other jurisdiction where you either seek licensure or you are currently licensed. This can all be done in that consent agreement, but I would eliminate the word voluntary from the nomenclature if I had my way, versus an adverse ruling, which I think all of these issues should have been deemed an adverse ruling or a final adverse ruling. It does a couple things. It makes it reportable, it makes it likely public, and it also triggers the right to an appeal and let that time period expire. So, and I tell you, we're throwing a whole lot of issues at you guys right now. And so hopefully you understand that. Reciprocal discipline, I thought I was on one of my last slides, but I have a couple more. Reciprocal discipline. So we'll ask ourselves, if someone is subject to discipline in jurisdiction A, does jurisdiction B have to reprove the wrongdoing, or do they just enter the final adverse action into the record? Most likely it's just enter the final adverse action. You don't need to retry something that's already been tried. And the due process rights were given to this person over in jurisdiction 1. And those due process rights are probably the same in different jurisdictions, or at least very similar. And so you don't need to relitigate and end up with potentially inconsistent judgments. So that's the purpose of reciprocal discipline, is an efficiency standard. Versus proof of wrongdoing, you have to retry this and show some wrongdoing. And this most likely will come up when you have jurisdictions that have differing grounds for discipline. So if I have an advertising violation in state A, and that action in state A would not have been unlawful, if you will, in state B, but state A whacks my license, I'm from Chicago, I can say whack, whacks my license, can state B take an action? I think the answer is probably yes. But in some jurisdictions, you may have a debatable point. So anyway, reciprocal discipline versus proof of wrongdoing and the efficiencies of the boards themselves. And I'm hoping I'm going to say, oh, I'm not going to say last slide on that one. So pre-licensure decisions versus post-licensure. And is it easier to deny an application for licensure than it is to remove a license once it's given? The answer is probably yes, from a legal due process standpoint. However, in this case, they revoke the right to renew, and that seems to be in a little gray area for me. But either way, these individuals were given their due process rights. But in many jurisdictions, if you deny a license, there's no right to appeal that internally, and there's maybe no right to a hearing. So you go right into the judicial system to debate it. So everybody probably understands that. And lastly here, in this case, the physician, while he was in Arizona, at first he was pro se, he represented himself. He eventually got a lawyer, but he said, I don't want to come back to Massachusetts to appear. And so we're going to do this somehow, either remotely or just through written correspondence and through my written submissions. And so, due process versus his election to not appear physically, if you will, in person to the board, so before the board. So you can think about how all those issues might implicate these particular matters. So now you all can exhale. Maybe I can exhale a little bit too. But I would ask if anybody has any comments or questions. We covered so many issues here. I understand why some of you might say, oh my God, that was too much. But it's amazing how one interesting fact pattern and one very short opinion can stimulate us to discuss so many different issues. And so I'm happy to try to answer any questions or refer them over to Rich if I can't answer them. So anybody have anything to say?
Dale, I'd like to acknowledge Mark Brengelman's comment earlier, just at the beginning, and he states, no matter what the document is, does, or says, it should state this, in quotation, is a disciplinary action, see FARB model settlement agreement template. So I just want to acknowledge that.
Yeah, and I agree with Mark's comment there too as well, and take advantage of access to models and others as well. But very good, Mark. Thank you. Other comments or questions?
Yes. So far, I'm looking. There are no comments or questions.
You guys still out there? Give me a thumbs up. Buck's going to win the Stanley Cup. Something. Somebody say say something. So, if there are no further questions, I will at least wrap up by saying a big thank you again to all those involved in putting this on. The biggest thank you goes to each and every one of you regulators out there, and for the important role that you play. Understanding your role and understanding some of the nuances of these issues is extremely important. And remember, issue identification is way more important than the answer. You need to see the problem before you can get to an answer. So hopefully these help you do that. And I will turn it back to you, Ruggie.
Thank you. Yeah, I'm trying to see if there are any questions, but it looks like people are just, expressing their appreciations more than anything else. And I'm just giving it, we do have 4 minutes. And yes, please do not forget to complete your feedback. That is very valuable to us. While we're possibly waiting for a question or a comment, I do have a comment because I do have the opportunity to be as a public member for another regulatory board, and would like to cite Dale's comments about letter of concerns, how sometimes a board might use it or not. And it's quite surprising, I was under the assumption everybody's quite keyed in to protecting the public. And I think that lends into our education about what our role are as regulators through FSPPT, because it really surprised me. We're serving for another board as a public member. I always have to challenge this regulatory board. Are we really protecting the public? Because from the onset, when I had my orientation, they view licensees as stakeholders. And I said, you're really viewing them as somebody on the table where our role is public protection. And so that was surprising. So, just very vaguely, I would tell you that I feel as a public member that they are overusing letter of concerns where there was an outright violation of rules and, in my perception, potentially harming the public. So I just like to comment on that and open it to anybody else who might chime in as to the view of a regulatory board, how licensees are and how they play roles. So you can go ahead and comment on that, Dale, more than a question.
Excellent. Appreciated those remarks. And Rich, by the way, Ruggie said that we had 4 minutes left. That's 8 minutes of billable time, just to let you know. So just to be sure.
I think the webinar's over.
Well, I'm still looking if anybody has any questions, but it doesn't look like it. All right. Okay. Thank you, Adrian. Stacy, rather. With that being said, it looks like we're close to being shut down 1 minute early. And thank you very much for participating. Have a great day, everybody.